Once again, we are forced to celebrate without Weah. On days like this, duality rarely exists. Grief has the power to swallow joy whole if we allow it. My youngest just turned 5 today, September 21st, 2025. And at every turn, grief is there with us. As we were not allowed to talk to her today. I don't believe y'all get it, so let's slow it down. They didn't just take something. They took my child. They took my child. They took my child. They tore away a piece of my soul. They tore away a piece of my soul. They invaded our sanctuary. They mocked my motherhood. They dismissed my humanity while pretending it was lawful. This is trauma of the highest order, and my children, my minor children, were there to witness it, and they feel it, they carry it. They can't let it go. So yes, I feel broken. I feel so broken. Because something sacred was broken. We still live in the same home that they invaded. Every day is reliving the trauma. And still, the system refuses to provide lawful remedy, to enforce rights, or to return my daughter. But let me be clear. If they thought taking her would silence me, they deeply miscalculated. I love my children far more than I would ever fear them or whatever may say it. If you know, you know. Now let's get into this document. Supplemental affidavit of continuous compounded harm. Defendant expansion and adjustment of punitive damages. Case number 253671, court. The 6th District Appeals Court by Heaven-Marshay, date September 20th, 2025. Regarding escalation of punitive damages, defendant expansion and compounded harm. Part 1, introduction. I, Heaven-Marshay, a living woman and lawful party of the record, submit this affidavit to explain the list of responsible defendants and to formally document the escalation of harm since the filing of my emergency complaint. This affidavit also preserves, for the record, the adjustment of punitive damages from $20 million to $50 million United States dollars. To reflect compounded violations, systemic dishonor, and willful misconduct across agencies, courts, utilities, and private actors. The escalation of damages is not symbolic. It is necessitated by the expansion of defendants, the breadth of misconduct now documented, and the irreparable harm caused by delay. Part 2, Defendant Expansion. In addition of the parties already named, the following entities and officers are hereby preserved as responsible for misconduct and harm: Public Utilities Commission of Ohio, PUCO, for issuing a fraudulent investigation within 3 days disregarding plaintiff submitted evidence allowing the illuminated company to continue billing and retaliating during the process, citing false balances and shifted blame onto the plaintiff. Northern District of Ohio for dismissing. I apologize. The Northern District of Ohio Court for dismissing plaintiff's emergency complaint as frivolous, despite evidence acknowledged by the Department of Justice as meritorious, refusing to permit filing of the amended complaint and evidentiary record despite prior notice, and returning filings under procedural pretext. The Sixth Circuit Court of Appeals for refusal to adopt the plaintiff's completed federal complaint and certificate of service submitted with the motion of limited remand, rejecting a lawful IFP filing under 28 U.S.C. 1915 and FRAP 24 based on stylistic differences, and obstructing remedy by relying on just jurisdictional shuffle to avoid ministerial duties. Part 3, Summary of Escalated Harm and Misconduct. 4, 30 days of unlawful separation. Plaintiff's daughter, Weah Naomi Nash, has been unlawfully withheld for over 30 days and continuing, causing irreparable familial trauma. Captured in statement for the record, 30 days of unlawful separation, ongoing harm, systemic negligence, and familial trauma. 5, coercive control and manipulation. Defendant Isaiah Miles Nash coached Weah into apologizing for lack of contact, training her to assume guilt for circumstances outside of her control. Capturing a statement of coach response and evidence of coercive control. 6, retaliation and procedural fraud by Bedford Court. Fraudulent suit pursued despite unrebutted jurisdictional challenge and lack of holder and due course proof. Capturing notice of fraud, retaliation, and procedural misconduct. Alley Bank versus Holt and Dowry. 7, obstruction of appeals court. Oh my gosh. Refused to file plaintiff's completed federal complaint and certificate of service alongside her motion for limited remand, or provide plaintiff with copy of filed documents. Capture and notice of clerks, obstruction and procedural fraud. 8, collection abuse. Ongoing fraudulent filings and collection harassment by a new debt collector with no jurisdiction to initiate a lawsuit. A lawful suit. Once again, Bedford Municipal Court has enabled further obstruction, retaliation, and abuse of power by permitting this case to proceed. Capture in observation of debt collection abuse and pattern of fraudulent filing. 9, unlawful service and witness trauma. Bedford police appeared at plaintiff's residence, escalating intimidation and re-traumatizing her children. Captured in affidavit of unlawful service, notice of escalated presence, and continuing witness trauma. Utilities for retaliation, illuminating company / PUCO, despite Despite being a named defendant and under investigation, the illuminating company threatened disconnection, cited false balances, and retaliated against plaintiff. The PUCO's investigation disregarded evidence, falsely claimed phone contact attempts, and ignored plaintiff's proof of payment, shifting blame unlawfully. Federal courts violations. The Northern District of Ohio courts dismissed a materious emergency complaint as frivolous, obstructed plaintiff's amended complaints and evidentiary record, and returned filings that should have been preserved. The Sixth Circuit Courts of Appeal rejected lawful filings and properly refused IFP access under 28 U.S.C. 1915 and concealed evidence by failing to docket plaintiff's attachments. These acts constitute retaliation, obstruction, and willful dishonor of oath at the federal level, directly compounding harm. Unlawful genetic testing and prosectorial misconduct. A plaintiff's minor daughter was subjected to an unauthorized genetic DNA test ordered by the Cuyahoga County's Court of Common Pleas without lawful jurisdiction, valid consent, or due process. Results of this unlawful test were transmitted by a Cuyahoga County prosecutor under the guise of child support proceeding, an act of intimidation, retaliation, and harassment designed to obstruct the plaintiff's established custodial rights. This constitutes a violation of the Fourth Amendment, protections against unlawful search and seizure, 14th Amendment due process rights, and further demonstrates prosecutorial overreach and systemic abuse under the color of law. Preserved in the record through objection of a genetic test submission and reassertion of lawful custodial standing. Part 4, Statement of Self-Representation, Burden, and Weaponization of Financial Trade. Let the record reflect, I, Heaven-Marshay, have carried the full burden of this litigation alone. Over 300 documents have been created, filed, and preserved solely by me, without the benefit of legal counsel, paralegals, or institutional support. This body of work, produced under the duress and constitutional retaliation, demonstrates diligence, good faith, and lawful standing that no party has lawfully rebutted. Rather than honoring this good faith, the system has weaponized my financial hardship and sheer frequency of filing against me. Each submission, each mailing, each certified service has been made necessary only by obstruction, misconduct, and petty refusals of the offers and agencies to fulfill their sworn duties. My time and labor are no less valuable than that of any judge, attorney, or officer of the court. I am a living woman, a lawful guardian, and a party of the record. To dismiss or diminish the weight of my filings because I lack a title, because lack of title is an act of arrogance, dishonor, and abuse of power. No other individual could be named who has borne this burden in the same manner, under the same conditions. I stand as proof of the systemic obstruction and retaliation embedded in this matter, and the record shall reflect that truth without distortion. Links to damages. This weaponization of financial strain is itself an actionable harm and a factor in the escalation of punitive damages from 20 million to 50 million United States dollars. The compounding costs, repeated resubmissions, and systemic escalation of my hardship demonstrates deliberate obstruction and willful dishonor by the very institutions sworn to provide remedy. These actions combined with the unlawful withholding of my child, federal court misconduct, and broader violations already preserved, justify both the increased punitive damages and the urgency of enforcement. Part 5, clarification of damages. The escalation from 20 million to 50 million United States dollars in punitive damages does not arise from the unlawful withholding of Weah alone. It reflects the compounded and systemic harm across every area of the plaintiff's life since the filing of her before the filing of her emergency complaint, including but not limited to denial of access to private trust and estates, refusal to process lawful and negotiable instruments, refusal to file plaintiff's declaration of status at state level even, denial of cash, food, and health care despite beneficiary rights, federal court's violation, dismissal of meritorious complaint as frivolous, refusal to file amended complaints and evidentiary records, improper rejections of lawful IFP filings, and the concealment of filing through jurisdictional shuffle, unauthorized genetic DNA tests, and blatant abuse under the color of law, fraudulent debt collection abuse and unlawful suits, retaliation and obstruction by public utilities and the PUCO, intimidation, harassment, and retaliatory law enforcement present, cumulative violations of oath and duties at every level of government and corporate authority. The punitive demanded 50 million USD therefore reflects the full scope of systemic dishonor, retaliation, obstruction, and harm, compounded by the federal court's direct violations of law and oath, separate from this total daily equitable charges of $50,000 per day, continue to occur until Nevaeh Naomi Nash is lawfully returned to the plaintiff's custody. Part 6, relief requested. The plaintiff reaffirms all relief demanded in emergency federal complaint and the completed federal complaint. It expands as follows. 1. The immediate enforcement of commercial instrument and access to trust property. Tangible restitution in form of vehicle, land, and unrestricted private credit. Full insurance settlements, vehicle, property, health, and generational. Federal filing and recognition of plaintiff's declaration of status. Permanent protection of rights and inheritance of plaintiff's children and bloodline, public correction and record sealing of defamatory and harmful records, written acknowledgement, written and public acknowledgement of wrongdoing by all responsible actors, immediate suspension of retaliatory state and local proceedings, punitive damages in excess of 50 punitive damage in excess of 50 million USD, reflecting compounded harm across all domains, including federal court's misconduct, daily equitable charges of 50,000 USD per day until Nevaeh Naomi Nash is lawfully returned. Part 7, closing statement. This affidavit captures both the expansion of the defendants and the adjustment of damages to reflect the escalated harm. The 50 million USD punitive damages now demand are proportionate to the compounded misconduct and retaliation inflicted since August 2025, and stand in addition to daily equitable charges. This is not to abstract exercise. It is lived harm. Each delay extends trauma, embeds injury into the minor child and her siblings, and undermines faith and due process. The courts and agencies involved have willfully disregarded lawful notices, verified deliveries, and so on earth. I reaffirm all prior filings, and I demand immediate enforcement of remedies. Any continued refusal to file, transmit, or lawfully or act lawfully will be preserved as further evidence or of willful misconduct and dishonor of oath, for escalation of higher jurisdiction and as necessary. Injustice anywhere is a threat to justice everywhere. Martin Luther King Jr. I am not behind, I am aligned. I speak the law of truth, not fear. Every false structure around me must fall. My words hold weight. My light reveals lies, and I stand protected spiritually, lawfully, and divinely. All rights reserved, all submissions made in truth, honor, and in good faith. By Heaven-Marshay Hope, livid woman, lawful guardian, authorized representative. All rights reserved, without prejudice. UCC 1-308. And let me be clear, I do not want to have to do this, but it has been made abundantly clear that even accountability must be fought for. I thought being gaslit at a home was unbearable. But being gaslit by an entire system, there are hardly words. This unlawful delay has only strengthened my claim in the span of a month. Even federal courts are willfully ignoring blatant violations, crimes, and harm, as if my claims aren't backed by the evidence. But the evidence is undeniable and too blatant to disregard. Period. When public servants bound by their oath feel comfortable violating the very laws meant to be protected by them, that is dangerous. They are not above the law. None of them. No further explanation is needed. The record already speaks for itself, and yet retaliation and escalation persists, as if fighting for my children and my rights is somehow wrong. And if that fight makes me wrong, then I don't want to be right.